Welcome, everyone. So great to see you here today. Welcome to session 1 of NACC's training for Ohio attorneys, high quality legal representation, focusing on practical skills for child welfare attorneys. My name is Kristen Pisani-Jacks, and I am the training director at the National Association of Counsel for Children, and I'm excited to be your trainer for our 4 weeks together. We're going to get into our material in just a minute, but a few housekeeping matters. You should have received in your welcome email a link to a box folder that contains resources for this session. We'll also update it as we go along with resources for all of the sessions. In addition, you can find all of our slides in that folder as well. I will leave some time for questions at the conclusion of our webinar, but I encourage you to put your questions into the Q&A tab as you have them so we can get to as many as possible. You'll notice that I'm joined by my colleagues, Daniel Trujillo and Christina Lewis. They'll be able to help out behind the scenes with answering questions that you might have in the chat. We're going to have a few moments for interactivity throughout, so we hope that you engage with us in those. And then, as you noted, today's session is being recorded. And after each of our webinars, you'll receive an email with a link to the session recording so that you can catch up on anything you may have missed. Without further ado, let's get into today's session, where we're going to be doing a deep dive into the reasonable efforts requirement. We're going to talk about the law, its intent, and advocacy opportunities around reasonable efforts. So looking at our roadmap for today, we're going to start by kind of talking broad. We're going to talk about the why, the financial framework. Then we'll get into the law in Ohio and federally around what findings are required and when, and what exceptions can be made. We'll spend some time thinking about what constitutes reasonable efforts and where you can advocate for reasonable efforts. And then we'll talk about reasonable efforts connection to sibling connections. We'll end with active efforts. And like I said, we'll leave some time for Q&A. So it's an ambitious agenda, but I think we can get through it together. But before we do, I would love to know who's in the room with us. So you have a poll here. All of our polls and word clouds are going to be in Slido. You can engage with this in one or three ways. You can scan the QR code that you see in the corner of your screen. You can go to slido.com and enter those numbers, or Christina is going to be putting the link for Slido into the chat and you can visit it that way. If you play more than one role in the system, for example, if you represent parents and children, you should be able to choose all that apply. If you don't see your role captured here, I encourage you to choose other and type it into the chat. And with this poll or any of the polls, if Slido isn't working for you, go ahead and just enter into the chat and I'll see you that way. So we'll give just another minute for you to finish up this poll. All right, looks like a few results are still coming in, but we've got a good mix of folks. About 43% of you are attorneys for the county or agency. Welcome. We've got around the same amount, almost exactly the same amount of children's attorneys and parents attorneys, around that 40 to 35%. We've got some CASAs and judges. I see you in the chat. We've got some trainers. I see an appeals attorney, a magistrate. Thank you all for contributing to the poll and to the chat. And if it didn't work for you this time, no worries. We will get you on the next round. All right, for each of our webinars, we are going to have a fact pattern of a hypothetical case based on some real facts, but tweaked, that we're going to use to really engage with the material and apply the law and best practices to the facts of these cases. So you'll find these facts in your folder as well. As you see, they're up on our slide, and we're going to go through them just briefly right now. So our hypothetical case here involves the Harris family. So the Harris family came to the attention of the agency when the hospital made a report that Crystal and her newborn Maya tested positive for opioids when Maya was born. And when CPS responded to the hospital social worker said she was concerned that the mother was not really bonding with the child and did not really want to hold her. The CPS investigator then interviewed Miss Harris, who reported a long history of heroin use, but stated that she stopped using when she found out she was pregnant and that she did have a prescription for methadone. She admitted to relapsing one time before Maya's birth, but swears she's committed to remaining clean. The worker noted that Miss Harris appeared despondent and that she did not observe to engage much with Maya. She reported a history of being diagnosed with depression and also struggling after the birth of her son. Maya was born 5 weeks early, is receiving treatment for opioid withdrawal. Her 2-year-old son, Jared, was being watched by Miss Harris's grandmother. So the CPS worker then visited, Jared and Miss Harris's grandmother, Janelle Jones, at Miss Harris's home and observed not many baby supplies for Maya in the home. She saw 1 pack of diapers, 1 container of formula, and a pack and play. Miss Jones said she lives a few blocks from Miss Harris. She babysits Jared from time to time, but she works nights and she's concerned about caring for both Jared and Maya without support. As a result of the investigation, the children were removed and they were placed in a foster home together. So again, we're going to come back to this case throughout our time together. But first, we're going to start with the financial framework undergirding reasonable efforts. So the reasonable efforts mandate derives from Title 4E of the Social Security Act, which is implemented through the Adoption Assistance and Child Welfare Act, as well as the Adoption and Safe Families Act. So when you hear reasonable efforts referred to, you'll often hear it referred to in connection to 4E funding. Because essentially what Title 4E requires is that the state make reasonable efforts in order to qualify for and remain eligible for 4E funding. As we're going to see in a minute, this is one of many funding streams utilized by the states, including Ohio. So you have this graphic here because you can think of reasonable efforts as both a carrot and a stick. It provides both an incentive to receive federal funding for doing certain things, as many federal laws do for the states. And it also provides a consequence. It carries with it a danger of losing federal funding if the states comply. And we're going to talk about this more later. I think it's helpful to show the numbers because when we talk about the consequences of no reasonable efforts, it helps to really ground ourselves in what we're talking about. So what you have here, and you can see the link in your materials, are child welfare spending in Ohio for fiscal year 2020, the most recent year where data is available. And you'll see that child welfare funding comes from three main overall sources. Federal funding, which comprises about 38%, state funding about 10%, and then the largest source in Ohio is actually local funding at 48%. And then this chart on your screen breaks down that federal funding. So you'll see here that Title 4E is the largest federal funding stream that Ohio utilizes. So of that 38%, about 82% of that is 4E funding. That's followed by about 11% for the Social Security Block Grant, 4% each for Title 4B and TANF, and then around a 1% or a little less for other sources of funding. So as you can see, there are many sources of funding that go into child welfare spending in Ohio, and I promise I'm going to tell you why that's important in just a minute. So you may be thinking now, or when you signed up for this webinar, a whole webinar on reasonable efforts. Why are we spending so much time talking about this one area of the law? Reasonable efforts law can be a really powerful advocacy tool that can be used to ensure that children remain at home, and when they have to be removed, that they can be returned home safely or achieve permanency timely. When caseworkers provide targeted, reasonable efforts that are timely and individualized to the family, they promote family stability and reunification and timely permanency. Reasonable efforts law ensures that children and parents receive the services they need to make progress towards their case goal. It also ensures that there is an accurate record throughout the case of what has been done and what hasn't been done. And that may become important later on, depending how or to what end the case progresses. And as we'll see, reasonable efforts is a key federal and state obligation of the agency. So I saw we had quite a few agency attorneys on our call today, and that's great because agency attorneys can provide this really important role of helping to translate the federal and state reasonable efforts law requirement into social work concepts that social workers and caseworkers can understand and make sure they're abiding by. And parents' attorneys, GALs, and children's attorneys, as well as CASAs, can make sure that they are advocating for the agency to fulfill its legal obligations. And when we think about the why, it's also important to think about what Congress intended when it thought about reasonable efforts. And really what it intended was to put some sunlight on what was going on in these cases and really to elevate the role of judicial oversight. So in the preamble to the Adoption and Safe Families Act, Congress said that what they intended with reasonable efforts was to really be an important safeguard against inappropriate agency action, that judicial determinations could help ensure that. And what they didn't want reasonable efforts determinations to become was a mere pro forma exercise in paper shuffling to obtain federal funding. But they said after reviewing information from the states, they were concerned it had become just that. So they re-emphasized that the primary concern of reasonable efforts determinations is that judicial decisions are made on a case-by-case basis. And they said this is not supposed to be overly prescriptive or burdensome. So essentially what Congress intended was to have meaningful hearings where the court receives evidence of meaningful, reasonable efforts that were either made to prevent removal or later to reunify the family or achieve permanency. So when you think about that congressional intent, I'd love to hear from you in this next poll of how well you think that congressional intent is being met today in Ohio on a scale of 1 to 5, 1 being not at all and 5 being, yep, fully, we're totally good on reasonable efforts. So when you think about, are you having those meaningful hearings where meaningful evidence on reasonable efforts is being presented? Are judges using those findings to be that safeguard? I'll give you just a minute to fill in. And just like before, if you can't access the poll, go ahead and enter your answer into the chat. So I see a mix here. It looks like the chat is pretty consistent with the poll. I see a lot of 3s and 4s in the chat, and those are our top 2 answers here too, and they're exactly tied. So looks like some progress, room to improve, follow, and then we've got our last 3 answers with a little less. So that is good to know. And as we dive deeper into the materials, you may have different answers or answers that develop for you. All right, so let's dive into the what of reasonable efforts. What findings need to be made? When do they need to be made? And what happens if they're not made? So first, we've kind of got this little cheat sheet here of many of the places you can find reasonable efforts, both in the federal law as well as in Ohio law. So you'll see it comes up many times in the Ohio Revised Code, Administrative Code, rules, as well as case law. So hopefully if you're looking to file something on reasonable efforts and you're trying to remember where you can find that again, you can pop right back to the slide. You have a little cheat sheet, and you'll see on the slides we've got some citations as well. All right. So with reasonable efforts, we're really looking at 3 key findings that the court has to make. This is enshrined both in federal law, Ohio agency policy, and Ohio state law. So any hearing at which the court either removes the child or continues the child removal, the court's going to have to make this reasonable efforts finding in Ohio. So the court has to determine whether the agency first made reasonable efforts to prevent or eliminate the need for the child's removal from their home. So that's the first finding we would expect to see in Maya and Jared's case. What were the reasonable efforts that the agency made in that case to prevent or eliminate the need for removal? Then again, at any hearing where the court is removing the child or continuing the removal, court's got to make a finding whether the agency made reasonable efforts to make it possible for the child to return safely home. So once Maya and Jared are removed, what efforts is the agency making to return them home? And finally, if the goal of the case changes, if reunification no longer becomes the objective of the case, the reasonable obligation remains, but shifts to reasonable efforts to finalize the permanency plan. So let's say way down the line that Mrs. Harris is not working her case plan, is not engaging in services, not visiting with the children, and the goal changes to adoption. The agency then is going to have to demonstrate, and the court will have to make a finding that it's making reasonable efforts to finalize adoption. So as I said earlier, when you think about when these findings have to be made and the consequences attached to them, it's helpful to think about it in two buckets. The finding that's required to qualify for federal funding and the finding that's required to remain eligible for federal funding. And the timing is different with each of those, as well as what the consequence is if that doesn't happen. Okay, so this is going to be a little knowledge check. If you don't know, it's totally okay. We're going to cover it, but I'd love to see where people in the room are. So one of these four statements is a true statement when it comes to reasonable efforts to prevent removal. So I know they're a little lengthy. Take a minute, read them over, and if one jumps out at you that, yeah, I think this is the true statement, go ahead and select it. Which of these is true around reasonable efforts to prevent removal? If you can't use the poll, you can enter the letter of the correct answer, what you think is the correct answer, into the chat. All right, I see a mix of A's, B's, and D's in the chat. And right now it looks like we're pretty closely split amongst those first three choices, D, A, M, B. So for the 27% of you that chose B, you've got it right on. So well done. Let's talk about why. All right. So reasonable efforts to prevent removal. That to qualify for federal funding, that finding must be explicitly made in a court order no later than 60 days from the date of the child's removal. If that finding is not made within those first 60 days, if the court makes a finding that the department did not make reasonable efforts to prevent removal, the agency cannot collect 4E funding for that child for the duration of the time they are in foster care. One way I think about this finding is the not fixable finding. It doesn't matter what findings are made later in the case. If that finding is not made, the child cannot receive 4E funding for the entire time they're in care. And so there may be some of you sitting on this webinar going, that seems really harsh. Why is that? So I've included links throughout to the Child Welfare Policy Manual. So the Child Welfare Policy Manual, if you're not familiar, is a way for states to get further guidance from the federal government on important areas of federal law, to ask for clarification, basically. It's not binding, it does not carry the force of law, but it helps to sort of explain the thinking of the feds. And the states asked about this. They said, would you consider not making this such a harsh consequence? Could we fix this, essentially? And the federal government said no, and here's why. It's impossible for the agency to provide efforts to prevent removal after the fact, right? Can't unring that bell. And from a practice perspective, the removal of a child from the home, even temporarily, makes a profound impact on a family that cannot be undone. In other words, the consequence is harsh because the situation is harsh. If the agency makes no efforts whatsoever to prevent the removal of a child and the court makes that finding, the damage to the family is already done, right? And so the consequence that attaches is that loss of federal funding. Now, in the Harris case, if the court makes a finding that the agency did not make reasonable efforts to prevent removal, does that automatically mean Maya and Jared go home? Love to see what you think in the chat. You can just hit a quick yes or no or Y or N. If in the Harris case, the court makes a finding that the agency did not make reasonable efforts to prevent removal, does that mean Maya and Jared automatically go home? All right, you guys are on it. I see nothing but no's, almost universal. Totally got it, right? No. Because that reasonable efforts finding is distinct from the removal decision. And we see that captured in both Ohio law and federal law. In some states, it does mean that the children automatically go home. But in Ohio, just like under federal law, it's a separate finding about why a child enters shelter care, right? So you see in the statute, the court can order shelter care if it's required to protect the child from an immediate or threatened physical or emotional harm, or the child has no one to care for them, essentially, right? Doesn't say anything about reasonable efforts. And same thing where you see the language of temporary custody, you see that the court can keep the child out of home if there's a contrary to the welfare finding, which is exactly the language you see in federal law. So finding of no reasonable efforts does not mean the child returns home immediately. All right, so that's reasonable efforts to prevent removal. That's that finding to qualify for federal funding. Now let's talk about the finding to remain eligible for federal funding. So here we are back again. We've got another poll. Here, I'd like you to choose all of the true statements, hint, hint, all of the true statements, maybe more than one, about the reasonable efforts to finalize permanency finding. So again, you can enter into the chat more than one letter if you see ones that you think are true. If you think only one is true, go ahead and choose that one, and I'll give you all a minute for this poll as well. All right, I see many of you chose C. Over 80% of you chose C. I also see C, A, D in the chat. I think I saw an E thrown in there as well. The next one is that I saw A. So if you chose C, you are correct. If you chose E, you are also correct. So let's talk about why. All right. So one way to think about this finding to remain eligible for federal money, is that it is fixable. So this is essentially a finding that has to be made annually. So the finding has to be made for the first time within 12 months of the first of either the date of adjudication or 60 days after removal, whichever one is earlier, and then at least once every 12 months thereafter. Now, unlike that finding to prevent removal, this loss of funding is not permanent. If the court makes a finding that the agency did not make reasonable efforts to finalize permanency, the child loses their Title IV-E funding at the end of that 12th month that the finding was due and remains non-reimbursable until the first day of the month when a new finding is made. So let's say, for example, In Maya and Jared's case, let's say this finding is due on October 31st. On October 30th, the court makes a finding that the agency did not make reasonable efforts to finalize permanency. Some time goes on, agency gets services in place. On January 2nd, the court makes a finding that the agency has made reasonable efforts to finalize permanency. Maya and Jared lose that federal funding starting on October 31st and until January 1st, just for that period of time where the no reasonable efforts finding was pending, okay? So whenever we talk about money, people tend to get nervous, right? Particularly judges when we do this training for judges. We've heard things before like, I don't want to make a finding of no reasonable efforts, or I don't want to ask for that finding because doesn't that just mean my client's going to lose out because they're going to lose out on money, or isn't the family going to lose out on money? And the answer is sort of, but not necessarily. And it's not really a one-to-one like people think of. First of all, for this finding, remember, this finding only has to be made once every 12-month period. So even if some of the findings during that period are that reasonable efforts were not made, as long as it's satisfied once during that 12-month period, funding is secured. In addition, remember that chart we looked at earlier. Title IV-E funds are not the only funding stream that Ohio utilizes. They utilize state funds, they utilize local funds, they utilize other federal funds. And further, there's no impact on the actual child or family. They are still entitled to services, they are still entitled to foster care. Services can't be taken away from the child just because there's a loss of IV-E funding. All right. Now in Ohio, as you know, and this may have influenced some of your answers to the poll, reasonable efforts findings are actually required more frequently, which is great, right? It's great to do it more often because it's such an important tool for families, and it makes sure you don't run afoul of those timelines. So really at almost every key point of the case, the court's going to make a reasonable efforts finding, right? At the temporary custody hearing, at adjudication, disposition, reviews, and permanency hearings. So this may mean that you're getting those reasonable efforts findings more frequently than within the first 60 days of the case or once every 12 months. That's great. What the federal government sets is those outer limits, and states can adjust to make them more frequent, just not less frequent. In addition, the federal law allows for reasonable efforts to be made concurrently to two plans. So the federal law says agencies may make reasonable efforts towards reunification and towards an alternate permanency plan. Ohio law actually states, and this is something that went into effect January 1st of this year, as you see, that the case plan for a child in temporary custody shall, makes it mandatory, not permissive, include an alternate permanency plan, unless it's documented that that plan's not in the child's best interest, and that efforts, reasonable efforts, should be made concurrently towards reunification and towards that concurrent plan. So again, federal law provides the floor and says, you may do this, and Ohio actually says, no, you are going to do this. So you should expect for a child in temporary custody to see reasonable efforts being made towards reunification as the primary plan, and then a backup plan, an alternate plan. And we know this is important because we know it's important that children not languish in the system, that they achieve timely permanency. And so we don't want to wait until reunification is ruled out to start efforts towards another plan. However, it's also important to ensure that the efforts are going towards that primary plan as well, that the alternate plan efforts aren't taking over the primary plan. All right, we have talked about when reasonable efforts findings need to be made, what happens if they're not, and why that's so important. And you may be wondering, is this always the case? Aren't there some times where we don't have to make reasonable efforts? And so we're going to get into that right now with, guess what, another poll. So under Ohio law, When are reasonable efforts to reunify a family not required? And you can choose all that you think apply. Again, use the chat if you want. But under Ohio law, when are reasonable efforts to reunify a family not required? You've got 5 choices here. Go ahead. All right, we've got a few choices for each of them. I'm glancing into the chat. I see a lot of A's and D's. I see a B in there as well and a C. And then looks like almost all of you chose A, involuntary termination, followed by convicted of aggravated assault, and then a little less for the other choices. So we will get to the answers in just a moment, but I want to return for a moment to the Harris case. So let's say Maya and Jared are removed from Miss Harris's custody and placed in shelter care. Before the adjudicatory hearing, the agency discovers Miss Harris had a previous child protection case in Indiana before Jared was born. Miss Harris tells them that her mother adopted her daughter through that case because she was unable to care for her at that time. Based on this set of facts, would you argue that reasonable efforts are required to reunify Maya and Jared in this case? And go ahead and just answer quickly in the chat, yes or no. I feel like I'm seeing more yeses than no, or it might actually be even. Yep, here comes some more yeses. Might also be influenced by your role. All right, so let's get into the answers and the Harris case as well. So what I want to say at the outset about this is these situations really should be rare. We use the word exception for a reason, right? Because research demonstrates that children fare better with their families. We also need to keep in mind the constitutional rights of parents and the reciprocal rights to family integrity that children have. So for the agency never to make efforts to reunify or to cease those efforts early in a case, we really need to strictly stick with the situations outlined in Ohio's statute. And you'll see that those of you who chose answer choices A and D were right on. Because in one of 5 situations, if the court must make a determination that the agency is not required to make reasonable efforts if it finds one of these situations is true. The first is parental convictions for certain crimes if the victim of the crime is either the child, a sibling, or another child in the household. And those include things like aggravated murder or voluntary manslaughter, felonious assault, aggravated assault, or assault. Note that that was an answer choice in the poll. Torture or cruel abuse, sexual crimes like rape or sexual battery, and trafficking or compelling or promoting prostitution. So again, convictions for very serious crimes where the victim is a specific class of person. The second situation is where a parent repeatedly withholds medical treatment or food if they have the means to provide it. And there is an exception written into the statute for medical treatment through prayer or spiritual means. So again, that previous CPS history in and of itself is really not enough unless it falls under this specific condition. The third is extremely specific. So again, we sort of threw in that chronic substance abuse issue, and that could fall into this category, but you need more facts. So if a parent has placed a child at substantial risk of harm 2 or more times due to alcohol or drug abuse, and they've either rejected treatment 2 or more times, or they've refused treatment that has been in a journalized case plan 2 or more times, the agency can cease reasonable efforts. So a very, very specific, fact-specific scenario. The fourth is abandonment, and the fifth is involuntary termination of a parent's rights with respect to the child's sibling. So again, not any child and not voluntary relinquishment, involuntary termination. So remembering back to the Harris case, you probably need more information before you can make a decision, right? You need to speak to or have the caseworker speak to folks involved in that original Indiana case to figure out what was the circumstance under which the sibling was adopted. Was it a voluntary relinquishment, or was Ms. Harris's rights previously involuntarily terminated? Okay. You might want to talk to the caseworker, the grandmother, other people who are familiar with the case, Ms. Harris, and see if she knows. And also you want to just think critically about how long ago that case was, whether the facts are related to this case, and whether that really means efforts should cease in this case. Remembering again that that's a pretty serious consequence to move away from that altogether. I will note there are additional grounds provided for in the administrative code. Of course, where a statute and a regulation conflict, the statute trumps, but they are sort of in line with what you already have in the code, which are a requirement if the parent is required to register as a sex offender, or if the parent has deserted the child under the statute. But if you have a conflict there, the statute, of course, trumps. So what happens next? So if the court finds under one of those 5 statutory provisions that no reasonable efforts are required to reunify the family, the court must hold a review hearing within 30 days at which they will set a new permanency goal and determine the efforts needed for that permanency goal. So if this happens on one of your cases, you want to be ready for that 30-day hearing to argue what the goal should be and what reasonable efforts should become. Because the reasonable efforts obligation never goes away. It continues and just shifts immediately to making reasonable efforts towards finalizing permanency instead of reunification. What about emergencies, right? So when we look at the administrative code, we see that if removal is necessary, the agency must request one of 3 findings. 1, either that reasonable efforts were made, or that reasonable efforts were not required for one of the reasons we just talked about, or that reasonable efforts were not possible due to the urgent nature of the child's removal. So we look to the statute to see more information about what that means. And we see that Ohio law says that if the agency removes a child during an emergency in which the child could not safely remain at home, and the agency didn't have prior contact with the child, the court is not prohibited from making that reasonable efforts findings just because of that emergency. In other words, you should be looking for evidence of 3 things when you're thinking about this finding. Was the child removed during an emergency? Was the child not able to safely remain at home? And did the agency have prior contact with the child? Essentially, this finding is to the effect of it's reasonable for the agency not to make reasonable efforts. And we see this reflected in federal law as well. So this question was also posed to the Child Welfare Policy Manual. And what the federal government said is, even when children are removed in an emergency situation, the court still has to think about reasonable efforts. They still have to consider whether services were or should have been provided. But the court can determine it was reasonable for the agency to make no efforts due to the emergency of the situation in light of exigent circumstances. So a judicial determination is always required, but it might be that due to the emergency, the fact that no or little efforts were made is deemed reasonable. But again, we don't want to let the exception swallow the rule, right? Not every situation can be an emergency. So if you're arguing for this finding or you're arguing against this finding, you really want to think about what was the actual emergency under which absolutely no effort whatsoever could be provided, right? Or what makes an effort reasonable in light of the emergency situation. So let's apply this to the Harris case. So we've got just a quick poll. Based on what you know about this case, were reasonable efforts not possible due to the urgent nature of the children's removal? And if you answer yes, I'd love to see in the chat what makes this constitute an emergency. If you answer no, why you don't think it was an emergency. And if you need more information, what would you want to know? What would you want to see? Feel free to engage in the chat in that way. So I see the circumstances about the adoption you'd want to know more about. A lot of no's in the chat as well as in the poll. About 58% of you say no, followed by need more information, followed by yes. And we'll dive a little bit into some of the efforts that will kind of add to our facts as we go through so that we can kind of figure out what we think would be reasonable in the Harris case or in some of your other cases. So we are going to start with going to move into defining reasonable efforts, right? We've been talking a lot about reasonable efforts, but we haven't really said what that is. So what would you expect to see in the Harris case? We've got a word cloud here. You should again be able to go to the same place, type a word or a couple of words in, and you can answer more than once if you want to. But if you were working this case, what would you be making sure the caseworker is doing? What would you be arguing for? What would constitute a reasonable effort towards reunification in the Harris case? And feel free to add them to the chat if you want to as well. Make sure to choose in your drop down that it goes to everyone if you want. That way everybody can see folks' answers. All right, we've got a lot of great answers here. You know how word cloud works, so you know the bigger ones are ones we've gotten lots of answers for. So we see mental health assessment, safety plan, substance abuse treatment, and drug screening. And I see that in various iterations here. I also see parenting time, parenting classes. I see contacting grandma. I see kinship, right? I see lots of visits and visitation in different forms. Finding a daycare for grandma, linked to financial resources and benefits. These are some really great ideas. Let me check that. I see substance abuse and visitation and safety planning and counseling in the chat as well, right? Really great suggestions. This is a really great word cloud. So reasonable efforts is not specifically defined in either federal law or Ohio law, which can be really frustrating for folks, right? The federal government said we did this on purpose, we intended it to be flexible, but for something so important, sometimes it can feel like, why can't you just tell us what it is? Why can't reasonable people can disagree about what's reasonable, right? But we can find some guidance federally and in Ohio. And in Ohio, one place to look is this definition of supportive services in the administrative code. And so when you think about the administrative code, you're thinking about really what is the agency's own policies. And that can be a really helpful tool for attorneys to know what the agency is supposed to be providing. It can be a helpful tool for agency attorneys too, to sort of sit down with the caseworker and say, have you done these things? And the reason I say look here is because we see that the definition of supportive services really looks awfully similar to what we expect out of reasonable efforts, right? Supporting the integrity of the family, preventing the child's placement away from the family, enabling a child's return home or to alternative permanency, and assisting a child to prepare for transition to independent living. So when we look further at that portion of the administrative code, particularly in subsections G and M, we see a bunch of different services listed that might constitute supportive services. The ones you see in blue are under G, and those are services the agency may provide themselves or through a community services provider. And the one you see in orange is under M, and that section of the administrative code says the agency shall make available a minimum of 3 or more of the following supportive services within the county. Okay, so in the Harris case, as I'm looking at this, as many of you pointed out, right, a reasonable effort or a service we might expect to see are diagnostic, therapeutic, or counseling services for Ms. Harris to address her substance use or possible mental health issues. A referral to a drug treatment program might be another one. Emergency caretaker, parent aid services, right? And if you see others on here that you think would apply to the Harris family, feel free to add them into the chat. But you can really use this section of the administrative code as a checklist of sorts, right? If you're trying to decide, is what was done early in my case reasonable? You can see at a minimum were some of these services offered or provided or attempted. Another important source of what constitutes reasonableness in your state is case law. So you can look at cases where your appeals court or Supreme Court upheld reasonable efforts or said no reasonable efforts weren't provided, and compare and contrast those to the facts of your case. The administrative code also has helpful language, not just about what services should be provided, but how services should be provided, because that how is an important piece of what makes something reasonable. And what it says is, if the agency determines an emergency exists, they shall immediately, no later than 1 business day, make supportive services available. In addition, if the agency determines either the child is in immediate danger of serious harm because of the parent's chemical dependency problem, or that problem is the basis for the abuse, neglect, or dependency determination, the agency shall develop and implement a safety plan and refer the parent to drug and alcohol addiction programs. So again, important to ensure the agency is following its timelines and following the guidance of what specific supportive services should be provided and when. The federal government also gave states a little bit of guidance through their child welfare policy manual. And one way to think about these categories is it almost summarizes best practices and reasonable efforts. Again, doesn't have the force of law, but is some guidance for us. And the federal government styles it in these 5 questions. One is thinking about, would the child's health or safety been compromised if they have been maintained at home? Again, this gets us back to thinking about those emergency situations and also thinking about whether services can be provided in the home, right? It recognizes the harm and trauma of removal and the importance of keeping families together wherever possible. So maybe a reasonable effort in the Harris case would have been to explore, could Miss Harris's grandmother temporarily move into the home and provide support? Or is there another family member that could fill that role? Another thing to look at is customization. To be reasonable, services should be individually tailored to the family, the parents, the children, and their specific needs. You should always be wary of sort of cookie cutter plans or the same services being offered over and over again in every case. They really should address the primary issues and barriers to reunification. So is giving Ms. Harris a phone number just to any methadone clinic, is that a reasonable effort towards reunification in this case? And if the primary issues identified are mental health services, mental health and substance use, is a referral to anger management for Ms. Harris customized to her needs? This also involves thinking outside the box and thinking creatively about what a family actually needs. And I saw several of you put things like that into the word cloud, right? So maybe a reasonable effort in this case is ensuring that Ms. Harris is connected with WIC so she can get more supplies for Maya. Third, we look at whether the agency provided service to ameliorate those physical, emotional, or psychological factors that would inhibit a parent's ability to maintain the child safely at home, right? That is what we should be focusing on. So in the Harris case, we want to try to figure out what protective factors Ms. Harris needs to build up in order to have her children return home quickly and provide services that bolster those factors. The fourth one is probably my favorite because I think it can often be overlooked, but it's really crucial. And again, it gets to how the services are being provided, not just what is being provided. Are there any limitations with respect to service availability? And it specifically cites to transportation, which we know is an issue in many cases. And if there are, what efforts were undertaken to overcome those obstacles? Right? Monitoring alone is not going to constitute reasonable efforts, or it should not constitute reasonable efforts. We should see some active level of assistance with engaging the family, figuring out what their needs are, and coordinating services. And in order to be reasonable, services need to be accessible. So we need to think about things like language translation, ADA compliance, where a service is being provided. Is it accessible to the family? Do they have transportation to get there? What time of day? Is it conflicting with the parents' other appointments? Has anyone explained what this service is to the family, right? Why therapy is recommended, why substance abuse is recommended, what different diagnoses mean. So if Ms. Harris is offered a substance abuse program that is located, is not accessible by public transportation and only has appointments during when she's supposed to have family time with her children, is that a reasonable effort? And finally, the last category looks at efforts that are consistent with the permanency goal. And it gives specific examples of what efforts to finalize adoption might look like: filing for TPR, listing the child on adoption exchanges, implementing child-specific recruitment activities, right? We know sometimes there are these sort of general recruitment activities that are undertaken, but ensuring that they're child-specific. So in the Harris case, is talking to the foster parents about adoption a reasonable effort in this case? All right, so thinking about those 5 categories, which are the ones that you'd like to further scrutinize in your advocacy? When you read those, were there any that really jumped out at you that you said, yep, I absolutely want to leave today and I want to make sure I'm really focused on how services are provided, for example, or reasonable efforts linked to permanency. This is our chance to kind of make a commitment to ourselves with our colleagues here in the room and say, here's what I really want to scrutinize in my advocacy. And it's something that you're doing already. Go ahead and recommit to it here, because then you know you are practicing along with best practices. I see some commitments in the chat to customization, limitations, and linking reasonable efforts to permanency. It looks like a lot of you really want to commit to focusing on case plan customization and limitations such as transportation. I love seeing that all of them have some votes. Hopefully this is something, again, you can take away with you today and really concretely integrate into your advocacy. Because what we really want this to be is a call for action. So there's this article in your materials by Jerry Milner and David Kelly. And really what that article talks about is that when we're evaluating reasonable efforts, we need to move past what has always been done and accepted and really scrutinize the services and efforts provided to families. So what Jerry Milner and David Kelly say in that article is, reasonable efforts around the country have largely been reduced to perfunctory findings without supporting facts. And common practice is to accept inadequate efforts as reasonable efforts. As a community concerned with the well-being of children and families, we have to ask ourselves some direct questions. And I will say, as I read these questions, if any of them resonate with you, if you've had any of these happen on your cases, feel free to share in the chat. Is it reasonable for a parent to have to use multiple forms of transportation to get to an hour of counseling that may be canceled when she arrives, or worse yet, may not even be what she needs? Is it reasonable to expect a referral for services alone will get a parent what they need to care for their children safely? Is it reasonable to expect a parent-child relationship to grow and flourish with only weekly visits in unnatural settings, such as social workers peer at them through a window? Is it reasonable to pay a foster family to care for a child, often far away from everyone and everything that they know, rather than keeping the child at home in the community they know and using that money to provide parents for what they need to care for themselves? And the authors answer those questions and they say, none of this is reasonable. Yet these are real world examples of the reality in our current system and what is accepted as normal. It is wholly unreasonable. So let's talk about your role as attorneys and advocates and the role you can play in reasonable efforts advocacy. And one thing to note is that reasonable efforts really starts before you even get in the courtroom, because you need to engage in that out-of-court investigation, collaboration with other parties, and advocacy to ensure that you know what efforts were provided and whether they were reasonable. Because the goal here really shouldn't be getting a bunch of no reasonable efforts findings over and over again. What the goal should be is that families get reasonable efforts from day one, that they get the services they need to parent their children safely at home, right? And so one thing you can do is look to these questions that are included in the Ohio Hearing Toolkit. That's in your materials. And these are supposed to be questions you're hearing from the judges around reasonable efforts. So these questions can really serve as a guide for you in thinking about what information you need to take into the court hearing. And I especially want to highlight the questions here for families, which is in the third box here, because these are things we all, no matter what our role, should really be asking parents and children. That's really the place we should start. What do you need? What has been offered to you? What else do you think could get your children home? Do you think what you're getting now will meet your needs and build upon your family strength? We know that it's the agency's burden to demonstrate reasonable efforts, right? If the agency determines reasonable efforts the agency determines removal is necessary, they must document for the court the reasonable efforts they made to prevent removal, or why, for one of those reasons we discussed earlier, reasonable efforts are not required. At any hearing on the child's continued placement, the agency must document for the court and ask the court to determine either that reasonable efforts were made and continue to be made for the child to return home safely, or reasonable efforts have been made, but the continuation of reasonable efforts to make it possible for the child to return home safely is inconsistent with the permanency plan. And if the permanency plan has been changed away from reunification, the agency must document and request that the court make the finding, that reasonable efforts have been made to finalize the permanency plan. So agency attorneys can ensure that the caseworker is aware of these legal requirements and prepare them to make proffers and make arguments that meet the burden. And attorneys for parents and children can make sure that reasonable efforts are being made by the agency and that another party or entity's efforts are not being taken to prove their reasonable effort burden. All right, so some important pieces of in-court advocacy. Attorneys should review carefully any reports detailing services and reasonable efforts. And if those reports are inaccurate or incomplete, refute them, request that they be amended so you have an accurate record. It's important for each party to detail their client's narrative on reasonable efforts. That might be the parent, the child, or the caseworker, depending on who you represent. Make sure it's clear how each client views the services, their participation in services, the benefits of services, and detail any issues in accessing services or in communicating with each other. You can also use the statute to argue for reasonable efforts. So at least in one place in the statute, on 417K3, you have this really specific language that if the court determines the agency has not made reasonable efforts to finalize the plan, the court shall issue an order requiring the agency to make efforts to place the child in a timely manner and complete whatever steps are necessary to finalize placement. That whatever steps are necessary is pretty broad. So if you're getting to this point in the case and you're making this argument, you can go to court prepared with what you think those steps are that are necessary to finalize permanency, kind of back to that scrutinization that we talked about earlier, one of those best practices. And you can also use court orders to address accessibility of services as a reasonable effort. It's important to also tailor your advocacy to make sure judges make the required findings. Bonus point in the chat if you know who this famous jurist is that we have pictured here. But let's start with federal law. So federal law can be summarized in this area that it is, if it isn't written down, it didn't happen. So the federal law says that reasonable efforts findings have to be explicitly documented, made in a case-by-case basis, and stated in the court order. And if it is not found in the court order, the only other acceptable documentation is the transcript where the hearing where the reasonable efforts finding was made. Not accepted to prove reasonable efforts findings are affidavits, nunc-pro-tunc orders. So it can't be that judge forgot to make the finding, realized it later and tried to backdate it, or court orders that simply reference state law. Even if the state law referenced contains a provision on reasonable efforts, there must be that explicit reasonable efforts finding in the order. These findings also can't use qualifying language. There was a question posed to the Child Welfare Policy Manual about whether qualifying language is okay, that some states were using language like, I'm making a reasonable efforts finding for federal funding purposes only, or this finding has no precedential effect. And the federal government said no. No qualifying language. If you add that qualifying language to a reasonable efforts finding, it is not a bona fide judicial determination. I'm checking the chat to see. Everyone knows that this is Judge Holler from My Cousin Vinny. And yes, he did also play Herman Munster. So a little pop culture in there. This next judge is a bit easier. I appreciate that probably all of you will know who this famous jurist is. But you'll see Ohio law substantially similar to federal law. Court has to make written findings about 3 different things. One, whether reasonable efforts were provided. And the statute said that the court must also briefly describe what services were provided and why services did not prevent removal and enable the child to return home. So what was provided and why did that not prevent removal? The court also must make a written finding if it makes a determination that no reasonable efforts were required. And if the court is returning the child home under a situation under which the agency is not required to make reasonable efforts, the court has to make a written finding about that as well. Just like under federal law, the only other acceptable documentation, if it's not in the court order, is a transcript. Affidavits, amendments, nunc-pro-tunc orders will not suffice. All right. Let's move into our next section. It's also important to ensure that when making this finding, judges are looking at the totality of the review period. Reasonable efforts is essentially a look backwards, not a look forwards. And we know in our cases that during that 12-month period, a lot of things can happen. You may have started working on reunification. You may have also worked on adoption or guardianship or something else during that period of time. And so folks inquired of the federal government, is the reasonable efforts finding about only the permanency plan that is in effect at the time the judicial determination is due? And the federal government said no. You can look at anything. We're not going to be prescriptive about this. What we're looking for are those meaningful permanency activities during that 12-month period. Even if that plan has been abandoned, what did the agency do during that entire 12-month period to achieve permanency? And were those efforts meaningful? So again, we're looking backwards. We're making sure the judge is including, considering the totality of that period and what efforts were provided. And finally, crucial to preserve the record. You want to listen carefully to any reasonable efforts proffers, and if you have an objection, object. It's important for preserving your record and making an argument later if you get to the permanent custody stage. Because as you may know, one of the exceptions to the requirement to file a motion for permanent custody is in situations where reasonable efforts were required to return the child home, but the agency has not provided services. So if you're trying to prevent a permanent custody motion from being filed on your case, you want to make sure you're carefully scrutinizing reasonable efforts throughout the case. It's going to be really hard for Ms. Harris to make this argument if her attorney has not objected to reasonable efforts at all during the course of the case. So it's important to learn the case law on reasonable efforts. And also, if you have a good case and you want to appeal, make case law and make sure that case law is strong. All right, we're moving right along and we're going to talk about reasonable efforts as a tool for sibling connections. So the concepts of reasonable efforts advocacy can be used to support joint sibling placement and sibling interactions. The same federal funding consequences are not attached to sibling connections. So although the law in Ohio and federally uses the language of reasonable efforts, courts are not required to make reasonable efforts findings around sibling connections. But it is a place to think about incorporating into your advocacy and ensuring that the agency is making the efforts they're required to. So Ohio law says that the agency is strongly encouraged to make reasonable efforts to place siblings together, and if they can't be, to make reasonable efforts to ensure they maintain frequent connections. The exception to these is the same, is that if either joint placement or ongoing visitation would be contrary to siblings' placement or well-being. So why is this in the law? What are the benefits of ensuring siblings are placed together or have frequent visits? I'll give you a second for this. What are the benefits of ensuring siblings are placed together or have frequent visits with each other? See a lot of words coming up over and over again. Bonding is a big one. Stability and connection. Reducing the trauma of removal, maintaining family ties. I see mental health. I see a lot about preventing trauma or minimizing trauma. Children aren't losing their entire family. I see heritage, one less loss. That was a very powerful addition. Let me check the chat. I see family connections and bonding as well as well-being. All right. So you all hit on these. Excuse me, this article is in your materials. We have often heard from young people who have had lived experience in the system that often they felt like their sibling was the only one who really could understand all that they had been through, particularly when they had been removed, right? And even when we think about for those of us who have not been involved in the system, often people's sibling relationships are one of the closest relationships to them, sometimes even closer than their parents. So as you all identified, it does give that continuity of family relationships and that shared history, memory, and understanding. I saw mental health in there a few times. Studies also show that sibling connections are a protective factor for mental health. They are related to improved school performance. Children who have connections with their siblings in care are less likely to exhibit internalizing behaviors like depression, anxiety. They tend to have better relationships with their caregivers and a better adjustment to their foster home. They have support after exiting care, higher rates of adoption, guardianship, and they experience placement stability. And I saw stability a few times in there as well. So knowing all these benefits, and you all identified so many of them as well, it's really critical to do what we can to enforce those connections. So what can advocates do? So one thing you can do is think about those common barriers that often come up and have a plan in advance to address them. I'm not going to go over all of these on this slide in detail, but these are just things to anticipate and think about, right? For example, If you are having trouble finding someone who can coordinate or transport to visits, if the caseworker is saying, I'm not able to do this as often as you would like, maybe identifying who that supportive person can be to facilitate that. If you've got a large sibling group that is difficult to accommodate, can you look at a licensing waiver or kinship placement? If siblings are going to achieve permanency at different times, making sure you're having conversations with caregivers before you get to permanency. All right. And it's important to engage children, parents, and caregivers in these decisions, right? What would they like to see? How often do children want to see their siblings? How often do parents hope their children will get to see each other? Especially important for foster parents, right? Especially if they're going to be asked to help facilitate, coordinate visits, making sure foster parents understand the importance of this, that this is a normative childhood relationship and experience that they should have. Of course, you want to monitor joint sibling visits and placement and how they're going, and take an expansive view of siblings. Children may identify lots of different types of relationships as their siblings: biological siblings, half siblings, step siblings, people they were raised with. They may have siblings that they've never met, and it's important to ask the child who they view as their siblings and honor those relationships. You want to advocate and ensure that the agency is abiding by the statute and their own policies around encouraging sibling visit and placement, and that the court reviews at every hearing those placements and contacts. And you can use all of the legal advocacy tools in your toolbox: reasonable efforts advocacy, motions practice, arguments, to ensure that you're getting the type, frequency of contact that your clients want. And remember that the exception to this is if it is contrary to the sibling's best interest or well-being to have joint placement or visits. So prepare to present evidence around that, whether you're for or against that. All right, we are moving into our last section. I see some of you have gotten questions into the chat, which is into the Q&A, which is great. If you've got questions, this is a great time to enter them to make sure we get to them at the conclusion of this section. So let's say Miss Harris is a member of the Little River Band of Ottawa Indians, and Maya and Jared are eligible for membership. Then we're going to be at a higher and a different standard, which is active efforts. And you can find active efforts law and policy in a variety of places, including the Ohio Administrative Code, federal law. We've also included a link here to the Bureau of Indian Affairs guidelines. This is not binding precedent. This is considered as sort of best practice and guiding language in implementing active efforts. And so you will see this in on the slides as well. All right, so first, what findings need to be made and when? So before a child enters foster care placement or before parental rights are terminated, the agency must argue and the court must be satisfied that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that those efforts have proven unsuccessful. So active efforts to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family. The BIA guidelines say it's recommended practice for a court to inquire about active efforts at every court hearing and actively monitor compliance. All right, so this is going to be our last word cloud. When you think about active efforts, what is something that might constitute an active effort to prevent the breakup of the Indian family? Contacting the tribe, tribal notification, I see, placing with the tribe, cultural engagement, family trees, kinship placement, tribal placement, identifying tribal family members, researching genealogies. Great, a lot of great answers here. For the purposes of time, I'm going to move us along. So when you're thinking about what constitutes active efforts, you want to think about that guiding language in both the administrative code, federal law, and the BIA guidelines. You're looking for actives that are efforts, that are affirmative, active, thorough, and timely, that are designed to maintain or reunite an Indian child with their family. You want to look at efforts that are towards allowing parents to access and develop resources to satisfy the case plan. Active efforts should also, as many of you identified, be provided consistent with prevailing social and cultural conditions of the Indian child's tribe. And they should be provided in partnership with the child, parents, family, and the tribe. And they should be tailored to the child, family, and the case. And I love this quote from the Bureau of Indian Affairs, which is, by its plain and ordinary meaning, active cannot merely be passive. So we should be looking for a little bit more. And we actually have much more guidance than we have around reasonable efforts. So the Ohio Administrative Code takes language right from the federal regulations about what constitutes active efforts. So you kind of have a built-in checklist here of 11 different things. It's not an exhaustive list, but it's definitely a place to start to determine whether active efforts have been provided in your case. And you all identified a lot of these, right? I saw a lot of times, including representatives of the child's tribe. I saw diligent search for extended family and contacting family members. I saw culturally appropriate, right, family preservation strategies. Keeping siblings together and regular visits. I saw utility assistance in one of there. I think that would fall under number 8, right? Assisting with those community resources. So this is a great place to start when you're trying to assess whether active efforts have been made. And finally, just like reasonable efforts, active efforts must be documented in detail in the record. So the agency has to provide a report or affidavit about what active efforts were provided and why those efforts were unsuccessful in allowing the child to remain at home anytime the agency recommends a foster placement, anytime they file a report, or before they file a TPR or PPLA petition. And the BIA guidelines give some recommended efforts to document what the family's issues were that were being targeted by reasonable efforts, a list of the actual efforts provided and why those efforts were chosen, how the agency provided active efforts, dates, persons contacted, and results of the active efforts provided and why the agency adjusted, whether the agency adjusted active efforts. And with that, I think we have made it to our Q&A. Christina, what do we have?
Yes, the first question is, does the 4E funding reasonable efforts discussion only apply to children in foster care, or does it also apply to a child placed in kinship?
Yeah, so that's a great question. So it depends on whether the child is like in foster care with a kinship caregiver or whether they're, oh, I see you have here about temporary custody. So this is only going to apply to children who are in agency custody. So only children who are in agency custody in some way. So if they're living with a family member in a licensed foster placement under agency custody, then yes. If not, then no.
Thank you. Can you have a permanency goal of adoption before permanent custody is granted?
I think yes, if I'm understanding the question correctly. So the agency can be working towards adoption and can be making efforts towards adoption before permanent custody is officially granted. Agencies may do different things, but in general, again, think about those concurrent goals. It might be that the agency is pursuing reunification at the same time that it's pursuing adoption.
How does the ICPC for kinship or parental placement play into reasonable efforts? I found this process is long and slow and hinders an out-of-state, non-offending parent from getting a child, and I don't feel that is in the child's best interest.
Great question, Lindsay. Yes, the ICPC is often long and slow and frequently doesn't operate within a child's best interest, especially when it's being applied to a parent. I think that is all things you should look at when you're making that reasonable efforts argument. So it's important to look at, again, the code, the ICPC regulations and the Ohio Administrative Code to determine what the timelines are and to make sure at least the Ohio agency has done what it needs to do. Now, sometimes with the ICPC, what's complicated is that the ICPC goes to the receiving state and we lose some control over the process. But what I would say constitutes a reasonable effort in that case is that the agency followed the process that they were supposed to follow. And if they didn't, or they were delayed in submitting materials or packets or things like that, I think you could have an argument that reasonable efforts are not being made.
How do you suggest dealing with magistrates who have back-to-back cases, they're double or triple booked, and they insist that you keep your comments very short? She keeps getting interrupted and trying to make her record, but can't because they're short on time.
Yeah, that's a common issue we hear, right? Especially with these. So a few things. One is if you can't make your record orally, I always say make it in writing. Always say make it in writing. You can either preview that for the court through a motion or a notice. Sometimes previously, I sometimes would notice the court that I was going to make a request for a no reasonable efforts finding. If I don't get to finish my whole argument in court, I might file something supplementally and ask for it to be reconsidered. I think also knowing just what's compelling to your jurist and what's going to make them listen. So for some judges, I'm going to make an argument about reasonable efforts and that's going to impact funding. Sometimes that might be enough. But also just kind of hitting the high points, right? If you know you're only going to have 2 minutes, then you've got to start with those most compelling pieces and then say, I'm happy to supplement this in writing. But usually if I'm getting cut off frequently and all of my other tricks haven't worked, I try doing something in writing so that my record is still preserved at the end of the day.
Thank you. Does the agency dismissing and refiling the complaint restart deadlines for reasonable efforts findings?
Yes, if it's a new case, so if the case has been dismissed and a new case has been started through a new complaint, yes, then that would be a new case, right? So, even if this complaint wasn't dismissed and refiled, let's say the Harris case is successfully resolved, but then unfortunately the kids come into care years later. Everything starts fresh. There still has to be those efforts to prevent removal, still has to be those efforts to reunify. So I think you're talking about those times where it's dismissed and immediately refiled, but still technically, I think that would constitute a new case and those new timelines would run. Good question.
And I think that's it.
I see another one. Is the TDM prior to removal enough of a reasonable effort to, I think is that team decision-making meeting, Lindsay? If that's a team decision-making meeting, I think I'm going to give the very lawyerly answer of it depends, right? It depends on what the facts of the case are. Generally, I don't know that one meeting would be enough of a reasonable effort, unless I'm misunderstanding the acronym. Feel free to clarify it in the chat for me. But maybe if it's a very productive meeting, maybe if lots of services are offered and tried at that meeting, maybe it definitely is an effort that could be considered. Is it enough? It's hard to say. I see another question in the chat. If the sibling is not really one, but the child considers one, will the court accept this as a sibling? I would make the argument, right? If that's in my client's interest or I represent a parent and it's in their child's interest to have those connections, I would make an argument that the agency should facilitate that contact. Again, if I'm making an expressed interest or a best interest argument. So I think I've gotten to all your questions. You had some great ones. We are going to be back next Wednesday, same time, 3 o'clock Eastern, for our second webinar, which is going to be on educational advocacy. We're going to touch on school stability, educational decision-making in both general education and special education, and then we're also going to dive a little deeper into special education. So we hope that you will join us for that webinar. As Christina said, we do love hearing from you. We make adjustments to our curriculum based on what you tell us, and you will have a short evaluation that pops up after, immediately after this webinar. Should not take a long time to fill out, but we do read them very carefully. So if there were things you really liked or things you really didn't like, tell us about it so that we can try to avoid them for future webinars or add them in. Could be content related, could be our style, the tools we used. If you really like the polls or didn't like them so much, tell us so that we make sure we, like I said, include them or avoid them. And with that, I think we've come to the end of our time together. Again, we look forward to seeing you next week, Wednesday at 3 o'clock, where we'll be talking about education advocacy in abuse, neglect, and dependency cases. Thanks so much, everyone. Great to see you.